Would the attorneys for the state announce their appearances on the record?
Yes, Your Honor. Good morning. Deborah Barrow on behalf of the state of Florida for case number CF 17826.
Good morning, Your Honor. Ryan Williams and Michelle Latham on behalf of the state of Florida for CF 1615738.
Mr. Loyd, good morning. We last met on January 26th to discuss your desire to either represent yourself or have the court consider appointing an attorney to represent you, and at that time you indicated to me that you had not had an opportunity to call your family to discuss the matter with them. Have you had a chance to talk to your family? A little bit? Okay. We're going to start back where we left off the last time we met, which is that you have the right to be represented by counsel. If you cannot afford to hire an attorney, the court will appoint one to represent you. And have you made any decision in that area whether you would like to be represented by counsel or want to continue to represent yourself? All right, if you'll hand that to the court deputies. All right, give me just a minute, Mr. Loyd. Let me take a look at this. Would you hand this to the state so they can take a look? Mr. Loyd, we are here today for an arraignment because you have now been formally charged with offenses against you, and the purpose of arraignment is to advise you of those charges and then to ask you to enter a plea to those charges you can enter one of three pleas: not guilty, guilty, or no contest. Then we'll talk about the appointment of counsel again, and then I'll set a pretrial and trial date. Now, I understand from your correspondence to me that you would like to invoke the right to have a copy of the indictment at least 24 hours before you enter a plea to that, so I'm going to factor that in. I'm not sure I'll ask you to plead today, but I am going to advise you of what the charges are. I'll bring you back next week and ask you to formally enter a plea to those charges. I'm going to direct the clerk of the court to provide you a copy of the indictments that have been filed against you so that you have a copy of the charging documents as you've requested to the court, and then we will have another session next week where I ask you to enter a plea to the charge. The other thing we're going to do today, and I mentioned this the last time we met, is I'm going to go through this very lengthy inquiry of you about your decision to represent yourself. I'm required to do that at every critical stage of a trial. Arraignment is one of those stages that's critical. And so I need your patience a little bit, and we really do have to converse about that when we get to that point. So first, let me talk to you about the charges that have been filed against you. So on February 17th of this year, the fall term of the grand jury returned 2 indictments that are formal charges. This is what the state of Florida is charging you with, Mr. Lloyd, and I want to summarize them for you. In 2016 CF 15738, you're charged in count 1 with first-degree murder with a firearm, and the victim alleged is Sade Dixon, and it's alleged that that murder occurred on December 13th, 2016. In count 2, you're charged, and that, by the way, is a capital offense for which you can be put to death in the state of Florida. In count 2, you're charged with killing an unborn child by injury to the mother, and that's alleged to have occurred also in Orange County, Florida on December 13, 2016. That is also a capital crime for which you could potentially be put to death in the state of Florida. In count 3, you are charged with attempted first-degree murder with the firearm. That's alleged to have occurred on December 13, 2016, and it's alleged that you shot at Ronald Stewart Jr. That is a life offense. The use of the firearm, were that to be found beyond a reasonable doubt by a jury that you discharge that firearm, would have a mandatory minimum sentence of 25 years to life. In count 4, you're charged with attempted felony murder. It's alleged that on December 13, 2016, that you attempted to murder Dominique Daniels by use of a firearm. That is a life offense in Florida, and that has a mandatory minimum because of the allegations of the use of a firearm. In count 5, you're charged with attempted felony murder, and it's alleged that on December 16th you attempted to murder Stephanie Dixon Daniels, and in the course of that event you used a firearm. So that is a life offense and also has a mandatory minimum. And in count 6, you're charged with possession of a firearm by a convicted felon. In 2017 CF 826, in count 1, you're charged with first-degree murder with the firearm of a law enforcement officer. In that count, it's alleged that on January 9th, 2017 in Orange County, Florida, you did murder Deborah Clayton, an Orlando police officer, and used a firearm in the commission of that offense. That's also a capital offense for which you could be put to death in the state of Florida. In count 2, you're charged with attempted first-degree murder with the firearm of a law enforcement officer. It's alleged in that count that on January 9th, 2017 in Orange County, Florida, you shot at Joe Carter, a law enforcement officer with the Orange County Sheriff's Office, and used a firearm in the commission of that offense. That's a life offense. It has a mandatory minimum because of the allegations of both the law enforcement officer as the victim and use of a firearm. In count 3, you are charged with aggravated assault with a deadly weapon. It's alleged to have occurred on January 9th, 2017. And it's alleged that you threatened to do violence to Antoine Thomas, and in the course of that event used a firearm. That has a maximum penalty of 5 years in prison or a $5,000 fine or both. In count 4, it's alleged that you committed a carjacking with a firearm on January 9th, 2017. that is a first-degree felony punishable by life imprisonment. And in count 5, it's alleged that you were in possession of a firearm by a convicted felon. So, Mr. Loyd, the maximum penalty for the greatest charges is death, and then you have the other penalties as I've outlined for you. You've indicated to me that you would like to be able to review the charges before you enter a plea, that you've not seen a copy of the indictments. I'm going to order the clerk to provide a copy of these indictments to you, and I'm going to bring you back next week. And we're going to talk at that time about how you wish to plead to those charges. I want to go through with you again what we talked about earlier, Mr. Loyd, which is that you have the absolute right to be represented by counsel. As you can understand, these are very serious charges. There are a number of them. As you heard, there are 3 attorneys from the State Attorney's Office who will appear on behalf of the state, who are trained in legal procedure and substantive law. Up to this point in time, you've indicated that you want to represent yourself and defend yourself against these very experienced trial lawyers. And so I want to talk to you about that decision once again. And I want to tell you that a lawyer's legal knowledge and experience could favorably affect you in representing you in this case, could result in obtaining information about your case through the use of discovery devices that will be very limited to you while you are incarcerated and in jail, that a lawyer might uncover potential violations of your constitutional rights, could take effective measures to address them, would ensure compliance with speedy trial provisions and statute of limitation provisions and other procedural rights that you're entitled to. A lawyer could identify and secure favorable evidence to be introduced at trial on your behalf. As I asked you last time we were here, Mr. Loyd, I asked you if you knew how many peremptory challenges you would get in jury selection. Do you know what that number is now for these kinds of offenses?
Y'all done? You done?
No, I have a lot more to talk about.
I want to talk to you.
At some point in time, if we can't talk to one another, then I may force you to have a lawyer so that questions can be answered. So if you choose to represent yourself, Mr. Loyd, at some point in time you have to. I'm talking, I can wait till next week to talk to you about the appointment of counsel, but I want to stress this to you today, Mr. Loyd. There is a clock that's sort of running now. We're going to get closer to trial. I'll set the trial next week when we meet. But I want to let you know that this time is ticking off where an investigation could be made into this case. And so you're losing some valuable time. And as I told you last time, you're pretty restricted being incarcerated in what you can do in terms of investigating and preparing for your case, where death is a possible penalty that could be imposed. And so I want you to think about that between now and next week. I'm going to talk to you at that time in length about the advantages of having an attorney and the disadvantages of representing yourself. I highly encourage you to think about having an appointed attorney, Mr. Loyd. You have the right to represent yourself, but you're going to be significantly limited in representing yourself in these very serious charges, and your very life is at stake. So I want you to think very carefully about that, Mr. Loyd. And I'm also going to talk to you next week about appointing standby counsel. And if you want to represent yourself, I'm likely to appoint standby counsel who will be available to you if you change your mind. And I'm going to talk to the state a little bit about whether they're seeking death in this case. If they are, I might appoint a mitigation attorney to start to investigate whether there would be mitigation evidence that should be presented to the court if we get to the point where the jury recommends death and the court's got to decide whether to impose that penalty. So if you want to wait till next week, I'll wait. But I'm telling you that there's time that's clicking away, Mr. Loyd, and you're losing some time that an attorney could start to work on your case. So let me ask you this. You want to wait till next week before we have this full conversation? Okay. So I'm proposing that we meet on March 1st. In the meantime, I'm going to get you a copy of the indictment. I'm going to direct the clerk to provide it to you in the jail cell. so that you can formally review the language. Then I'm going to ask you next week to enter a plea, either guilty, not guilty, or no contest. If you enter a not guilty plea, then we're going to talk about appointment of counsel. In fact, no matter what plea you enter, we're going to talk about the appointment of counsel. Do you have any questions about where we are or what we're doing?
I guess y'all can get the meeting listen to everybody know I had court setting.
All right, well, I'll tell you today when you have court next week, so it doesn't come as a surprise. Is that all right? All right, so we're going to meet next Wednesday, March 1st at 10 o'clock in this courtroom. And at that point in time, I'm going to ask you to enter a plea to the charges and talk to you about the appointment of counsel. In between now and then, Mr. Loyd, just please give very careful thought to how serious these allegations are, that you're up against trained, experienced trial lawyers. And in many ways, it'd be like you're in a fight with your hands tied behind your back in terms of your experience level with criminal procedure, the evidence code, the rules, and their experience with those areas. So it's going to be very difficult for you to represent yourself. If you insist on it, you have that right. But it's something I discourage anyone from ever doing. So you're not the first person I've said you should think very carefully about how disadvantaged you would be if you don't have a lawyer by your side to help you. All right, Mr. Loyd? Any questions? All right, I'll see you next Wednesday at 10 a.m. in this courtroom. Okay, thanks. And Madam Clerk, if you would send a copy of the indictment. Anything from the state at this time? Okay.
No, Your Honor.
You available next week at 10? Someone will be here, I presume.
Yes, someone will be here.
All right, thanks, everybody. Clerk, will you file this?